Did you know that before 1972, you could go to jail for giving contraceptives to an unmarried person? It's true, and William Baird did. Baird was arrested not once, not twice, but 8 times across 5 different states for violating laws regarding the discussion and distribution of birth control. William Baird is a reproductive rights activist and a pioneer in the fight for contraception access in the United States. He became widely known for his efforts to challenge restrictive laws regarding birth control and abortion. In 1967, William Baird was arrested in Massachusetts after giving a contraceptive to a woman following a lecture on contraception at Boston University. Under Massachusetts law, it was illegal for anyone other than a physician or a pharmacist to distribute contraceptives, and they were only allowed to be distributed to married couples. Thomas Eisenstadt was the sheriff of Suffolk County, Massachusetts, where Baird was arrested. Eisenstadt was the appealee representing the state in enforcing its law against Baird. Baird appealed the conviction, arguing that the Massachusetts law violated the Equal Protection Clause because it discriminated against unmarried individuals by denying them the right to access contraception. Could simply giving a pack of vaginal foam to an unmarried adult be constitutionally prohibited? The United States Supreme Court ruled in favor of Baird in a 6-1 decision, as 2 of the justices were not yet sworn in, holding that the Massachusetts law was unconstitutional. The court reasoned that the right to privacy and access to contraception should not depend on marital status, and that the law violated the Equal Protection Clause. In concurrence, Justice Douglas felt that the First Amendment protected both Baird's lecture and the expressive conduct of distributing the contraceptive materials. Also in concurrence, but focused on the regulation of distribution, Justice White and Blackmun argued that there was no plausible health reason for this limitation to licensed professionals, and so the court should not have needed to reach the issue of distinction between married and unmarried couples to resolve the case. In dissent, Justice Berger argued that the states had rational interest in ensuring that its citizens received advice on contraceptives only from those who are credible sources of knowledge. One of the most famous quotes from the trial comes from Justice Brennan, in which he says, "If the right of privacy means anything, it is the right of an individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether or not to bear or beget a child." This decision effectively legalized premarital sex in the United States. Eisenstadt v. Baird reinforced the idea that the Constitution has an implicit right to privacy from the government and establishes that the choice of whether or not to conceive a child lies within this right, regardless of marital status. Eisenstadt v. Baird was part of a wider string of cases that sought to establish the position of reproductive rights and bodily autonomy amongst women. 7 years prior, in 1965, the Supreme Court established the right of married couples to obtain contraceptives from healthcare providers via Griswold v. Connecticut. Eisenstadt v. Baird expanded upon this ruling, extending it to unmarried couples, and laid the foundation for later cases, notably Roe v. Wade. Roe v. Wade was passed a year later in 1973, but then controversially overturned in 2022, nearly 50 years later. Beyond just expanding the right of privacy in the United States, Eisenstadt v. Baird speaks to the shift in societal norms regarding sex and reproduction during that time period. It contributed to the women's rights movements that were occurring during the 60s and 70s, as well as the government's role in regulating and enforcing morality. Eisenstadt v. Baird remains relevant decades later as the country continues to debate decisions of bodily autonomy and reproductive health today.